Should be good. Good afternoon, everyone. Hopefully everything is working, and I think it's we've just hit 12 o'clock, so we are good to go with today's webinar, coming to you from Kelly Santini in downtown Ottawa. Welcome. My name is Keith Gallup. I'm the Director of Client Services here with the firm, and I'll moderate today's session, which really includes this introduction, reading some questions out at the end, and hoping the technology keeps us going for the next little bit. Today's topic is employment law issues in M&A, and I'm speaking with the employment lawyers. Sometimes the forgotten element of negotiations when companies are going through mergers, acquisitions, or sales. So JP, over the next about 30 minutes or so, is going to talk through a number of the key scenarios and different situations that and different aspects of employment law that come into play when you are going through these negotiations. JP is our speaker. He is JP Zubec. He is a partner in the employment law group here at Kelly Santini. He, as an employment lawyer, naturally, he spends a lot of his time dealing with employees and companies who are in conflict due to disputes about employment issues. But he also increasingly spends more and more time working with companies on their employment policies in the hopes of helping them avoid a lot of these disputes from arising in the first place. Over the years, he has spent, you estimate, what, about 50? He'd been involved in about 50 merger, sales, and acquisitions transactions. So lots of experience that he's going to rely on as he takes you through today's presentation. And just before I turn things over to JP, a couple of quick things on today's presentation. First off, the handouts, the slides from today's presentation are available through your GoToWebinar control panel. You should be able to download them there. A couple of recent webinars, people have had trouble doing that. If case, just drop us an email and we will happily send those along. And second is, of course, we will save some time towards the end for your questions. So please send them in as today's presentation goes along. There should be a dialog box again in the control panel for you, and we will get to those towards the end. So JP and I are sitting side by side. You'll see my name but besides JP's face, but not to worry. We're just sitting in the same room, so we have one login, and we're just going to play some musical chairs, and I will turn things over for JP. Thanks for tuning in.
Thanks, Keith. I was preparing for this yesterday evening, and I was, why the hell did I agree to this? I haven't done this before. I was a little nervous about the format. I started actually a cast of talk show hosts, wondering how they even introduce them. I noticed that many of them just start talking about stuff about their lives, and I also thought, well, I don't really have that much of an interesting life to talk about, so I'll skip all of that. Hope you're enjoying your first full day of spring, and you enjoyed some time with your families at spring break. I will get right to the seminar, and the first slide involves understanding some basic concepts. And by the way, please chime in with any questions. It's kind of strange just staring at a screen and talking. Basic concepts of employment law that you have to understand in order to understand what I'm going to be telling you throughout the seminar. So employers owe obligations to employees from essentially two sources. In Ontario, there's the Employment Standards Act. That's the provincial minimum. It sets the provincial minimum standards, employment standards. I noticed that there are some people joining us from Fredericton in Montreal. Welcome. Had I known that, I would have suggested we go on tour and make shirts and all that. We would have opened in Fredericton. In each province, New Brunswick, Quebec, elsewhere, they have their own provincial legislative standards for employees and employers. So in Ontario, that's the Employment Standards Act, and it establishes things like the minimum wage, minimum vacation time, and it also contains obligations that are imposed on an employer when an employer is dismissing an employer, terminating the employment relationship, and that's important to understand. So under the ESA, there are termination entitlements or obligations, which are roughly a week per year of service up to 8 weeks. So it's a notice or pay in lieu commitment. So it would be, if it's a pay in lieu, you're talking about continuing salary and all benefits for that period of time. Also, in addition to that, there is a obligation, which not all employees qualify for. You have to have more than 5 years service, and the employer's payroll has to be greater than $2.5 million annually. If those requirements are met, it's an additional week of wages per year of service up to 26 weeks. So that's your ESA obligation. Your common law obligation is different, and it's more expensive, and it's often overlooked by employers, by accountants that are advising on transactions. The common law obligation is essentially set by judges. It's an implied term in all employment contracts that requires the employer to provide the employee with reasonable notice when terminating the employment contract. What is reasonable? It's not a mathematical calculation like the ESA. It's based on the employee's age, length of service, character of employment, and the availability of other employment. And roughly, depending on those factors, you're looking at an obligation of 3 to possibly as much as 26, maybe in some unique cases even a little bit more than that, 26 months. So the common law, so there's the ESA reviewed, the ESA termination obligations, and then there's the common law termination obligations. The common law termination obligations can be eliminated with a proper employment contract. And when I refer to the common law obligations, it includes the ESA payments. So let's say you fire an employee or dismiss an employee as a result of an acquisition, and the employee has a 5 years service under the ESA, 5 weeks notice or pay in lieu of notice would be owing. And let's say the common law judge determines that, for the sake of discussion, 7 months is owed to that employee. Well, that 7 months would include, it would factor in the payments made under the ESA. One final concept for you to understand, and I hope I'm not getting too heavy, please ask questions if I'm getting too technical, is the duty to mitigate. That means essentially an employee cannot be dismissed, go home, sit on the couch, not look for work, and sue the employer for every cent owing. The employee has a duty to go look for work, and if the employee finds work, whatever dollar earned is reduced from the damages award. That concept, the duty to mitigate, applies to the common law claim. It does not apply to the ESA obligation, and that becomes important later on in the when you're dealing with particularly asset purchases. So common law, a duty to mitigate does exist, and every dollar earned is reduced from the damages. Not the case with the ESA. So with that in mind, I'm going to move on and get to what you're here for. So, employment issues in a share sale. The obvious conclusion, I think probably to everyone, is that share sale, the purchaser automatically steps into the vendor's shoes, and all obligations, liabilities continue. They're tied to a share sale in terms of employment. And by the way, in my experience, typically employment considerations are an afterthought on these deals, but it's a pretty good idea to at least think of them and get an employment lawyer involved relatively early on in the process before you make a commitment on the structure of the deal, whether it's an asset purchase or a share purchase. So the upside on share sale is that the purchaser doesn't have to make any offers of employment to the employees, which is great in some cases if you want to maintain these employees. However, the downside is that you can't pick and choose amongst the employees you want to keep. That liability flows over to you. Their service with the vendor flows through in terms of determining their common law obligations and their ESA obligations. Employment contracts can't be unilaterally changed by the purchaser. So what that means is there's in law, for obvious reasons, an employer can't just simply come to an employee in the course of the employment relationship and say to the employee, I'm reducing your salary by $20,000. That's typically what is referred to as a constructive dismissal. It's in the eyes of the law, you're essentially terminating the employment contract, and then there's a financial liability to the employee. So if you're buying a business, you're buying the shares of a business, and you want to change the terms and conditions of the employment contracts with the employees, you're going to have to negotiate that with the employees. You're going to have to provide the employees with something called fresh consideration to get them to sign off on the new contract. Fresh consideration is typically, in employment, it's an offer of employment, like a new employment, but that's not going to happen in a share sale because the employee's already working. But it's typically a salary increase or a signing bonus. It could be a frozen turkey. If the employee accepts the consideration and signs off on the deal, well, then you have a binding contract. But you just cannot unilaterally change the terms and conditions of the relationship. The contract will be unenforceable. If you can't get a deal with these employees, your option is then to terminate their contracts. Typically, that would be with notice. You're going to give them a lot of working notice, and then offer them new terms at the same time. So you're going to offer them, you're going to say to them, look, effective 1 year from now, your employment with this company that I just purchased the shares of is ending, but we would like to keep you on, and 1 year from now, we are offering you employment on these terms, and you can close the written contract with the employee, with the letter. Okay, employment issues in an asset sale. For the vendor, this is a key consideration. The first one is that unless you're going to retain the employee or employees elsewhere in your company, in your operations, your employment contracts with these individuals are going to terminate. And this could be a very significant liability, depending on the amount of employees you have. If an employee becomes unemployed as a result of a sale, an asset sale, the vendor is responsible for fulfilling the obligations under the ESA, which I explained earlier, in the common law. And again, it has the sort of an estimate of the potential common law range. So when you're negotiating these sales, it's in the vendor's interest to negotiate a term that requires the purchaser to make offers of employment to as many of the vendor's employees as possible. In some cases, you're going to see other conditions that go along with it, such as the vendor is liable for termination costs if an employee is terminated in the first 2 months by the purchaser. That happens, and you got to negotiate, what does that mean? Does it mean liability for punitive damages if the purchaser is going to terminate the employee in a high-handed, offensive manner? Or is it just damages for notice, the contractual damages, or the payments under the ESA? So the purchaser in an asset sale, it could be good, it could be bad. I guess typically good. You don't have an obligation to offer employment to anyone. You can pick or choose the employees you want to make offers to, subject to human rights considerations, which I'll get to in a moment. Conversely, though, each employee doesn't have to work for the purchaser. So this is a very important consideration when you're purchasing a business that's run by key employees. You want to make sure that a condition of the asset purchase is that you are going to lock up those key employees to contracts, and those contracts are going to have non-solicit, non-comp provisions that will prevent those key employees from running off the business one day after the closing date. Now, in an asset sale, if a purchaser does make an offer of employment to an employee of the vendor, there is a section in the Employment Standards Act that effectively preserves the employee's rights. It treats the change or the transition almost like a share sale, where the new employer, the purchaser, has to recognize the employee's service with the vendor for all purposes relating to the act, including calculating the termination entitlements that may flow at some subsequent date. Now, the three most common scenarios in an asset purchase are the vendor's employee accepts employment with the purchaser within 13 weeks of the closing. And in that case, Section 9 of the ESA is going to apply. The vendor will not be liable to the employee for any ESA termination payments. The Section 9 essentially, it deems that the employment relationship was not terminated or severed under the ESA, and the employee continues working, and the purchaser assumes all liability for accrued service. The employees have a claim for common law against the vendor, because remember, the vendor is terminating the employee. However, it's likely nothing, because the purchaser is typically paying the employee the same level of compensation. So the duty to mitigate kicks in, where the employee will have a claim against the vendor for common law notice. Let's say it's a high claim of 26 months. However, the employee is earning the same level of compensation working for the purchaser now, so that claim is effectively nothing. Option or scenario 2 is the employee of the vendor rejects an offer of employment by the purchaser. Occasionally happens. In that case, the vendor is liable to the employee under the ESA. So those amounts are payable. And the employee may also have a viable claim against the vendor, a common law claim. However, the employee is going to have to explain to the court that the decision to turn down work from the purchaser was reasonable, and that's a pretty difficult test to meet under the circumstances. You're going to be working in the same place, assuming you're being paid the same level of compensation, doing the same job. The decision to turn down work 9 times out of 10 would be unreasonable. The employee would be deemed to have failed to mitigate his or her damages, and therefore the common law claim would be nothing. Finally, number 3, the purchaser does not offer employment to the employee to an employee of the vendor. In that case, that's your straightforward wrongful dismissal case. The vendor is liable for the full freight, both ESA and common law obligations, subject, of course, to the vendor having a good employment contract that would eliminate the common law claim. All right. You mind if I look at that? So, suggestions on how to reduce liability. Both parties, purchaser and vendor, should be getting the employees to sign off on employment contracts that have an enforceable termination provision. These contracts will limit the employee to the statutory minimums only when the employee or if the employee is being dismissed. So if you're on for or acting or advising for a business that is thinking about selling its assets, you want to, as soon as possible, see if you can roll out new contracts or make sure that the contracts in place have enforceable termination provisions. There's been a number of recent decisions in this area of the law where clever plaintiffs' lawyers have made highly technical arguments that have been accepted by the court, and what has happened is the court has determined that many types of termination provisions are invalid, and therefore the employer is on for the full common law liability. So you want to have these contracts reviewed or drafted by a lawyer who regularly practices employment law. In an asset purchase, you want the purchaser to identify the employees that it would like to keep as soon as possible. That way, the employees are going to be addressed very soon, early on in the process, which allows the vendor to give working notice to all of its employees. Working notice means, look, we're selling the assets of our business. The deal closes 5 months from now. It's typically not that long, though. We're going to be terminating your employment 5 months from now. Well, every day of working notice is a day of pay in lieu of notice that the vendor does not have to pay. So you want to push back that closing date as far as possible so you can reduce the actual cash payments you're paying out to employees who are not continuing on with the purchaser. Oh, okay. Unionized environments. Unionized environments are a completely different beast. Bargaining rights, once secured by a union, are protected and flow through to a buyer. Whether it's a share sale, it's obvious. It's first principles of contract. You buy, or I guess it would be corporate law. You buy a company, the shares of a company. You're stuck with all its obligations, including its commitments under any collective agreements. However, there is a section under the Labor Relations Act, this is again an Ontario statute, that applies to asset sales. And essentially, what you'll see is an employer sells the assets of its business, and a portion of that business continues on and is operated by a different employer. You'll see the union apply under Section 69 for a declaration that the successor employer is bound by the collective agreement. So in unionized environments, typically, unlike an asset sale involving a non-union business, and a purchaser can't pick and choose the employees it wants to keep. What you can expect is that that collective agreement is going to apply. So if you don't hire on any of these unionized workers, you can expect the union to get a declaration from the Ontario Labour Relations Board that the collective agreement applies, and an order reinstating some of these employees who did not receive offers with back pay. Okay, human rights considerations. These often arise in an asset sale. And they often relate to the decision by the purchaser in terms of which of the vendor employees it is going to make offers of employment to. So the most blatant, and I've seen this happen, the most blatant example would be we're going to offer employment to every one of the employees in this division that we're buying the assets of, except for any employees on maternity or paternal leave. That's an obvious violation of the Human Rights Code. Sometimes it can be a little less subtle. So what the purchaser has to do is it has to, first of all, be aware of any employees who are on a leave of absence. And it has to make sure that the distinctions it draws in terms of the employees it's hiring and not wanting are not based on any human rights, I guess, distinctions. Now, a purchaser in a share or asset sale should be also considering and determining which employees are being currently accommodated. For example, employees may be on a leave of absence because of a disability or an illness, or accommodations may be as insignificant as a stand-up desk because of a sore back. Well, the latter type of accommodations shouldn't impact the purchaser's decision, but the former requires the purchaser to keep the job open for the employee when he or she returns, and there could be a work hardening process, and the employee may not be able to resume all of the essential duties of his or her job without accommodations. So, there is an accommodation process that that a purchaser will have to go through, which can be inconvenient, but the Supreme Court of Canada said, so what? It's a small price to pay in comparison to the public policy interests of employing employees who are, for example, disabled. Reading my notes here, I think that covers that. If I have not covered anything, please send a question. The mass terminations, I won't get into this too much. There's some information in the slides here, but what should be known is under the ESA, the termination obligations of, this would be typically a vendor in an asset sale, increase if there's a significant number of employees who lose their jobs within a 3-month period. You have your numbers there. They're referred to as mass terminations. So that would be, you'd want to take that into consideration when you're determining the potential liability that would be triggered by a sale, to determine, ultimately what's your take-home profit. There's also, an increased exposure to severance pay under the ESA in some circumstances. If a severance occurs because of a permanent discontinuance of all or part of an employer's business at an establishment, and the employee is one of 50 or more employees who have their employment relations severed, well, typically in that case, severance is going to be owing anyway, because one of the thresholds is the employer's payroll. It has to be $2.5 million or greater, and if you're an employer that has 50 or more employees, 50 times an average salary of $50,000 comes in around $2.5 million. So I'm not sure if this really practically increases the exposure to severance pay, a vendor's exposure to severance pay. Restraining key employees. I'm not going to get into, well, let me back up for a second and sort of talk about the macro concept. You're buying a business, whether assets or share. If that business is being operated by key employees, you want to make sure that you are binding those employees to restrictive covenants that prevent the employees from walking off and taking a bunch of the business with them. Now, the rules in terms of restrictive covenants depend on one significant distinction. Are these restrictive covenants, when I say restrictive covenants, mean some sort of covenant and a commitment to do something in the future that restricts the employee? The two obvious or typical ones are non-solicit, meaning the employee can quit and go work elsewhere in the same industry and compete against the employer, but the employee is coveting to not solicit any of the former employer's clients. The other one is non-competition, which says the employee is not going to leave and compete against the employer within a certain geographic radius. So if you're going to include these restrictive covenants in the actual purchase agreement. This is when you're dealing with an owner-operator that's going to stay on as an employee. That is the preference. That's the best way to go. The court, essentially, the approach of the Supreme Court of Canada is, look, there's no inequality in bargaining rights. You have a buyer and a seller of assets or shares, certainty of contract. Essentially, you have two sophisticated parties that are making commitments, and the court's going to hold them to those commitments. So if the seller says, look, I'm going to continue to work for you after the close, the former owner-operator, and I'm going to agree to be bound by a non-competition provision that prevents me from competing in that same city for 5 years, generally speaking, the courts are going to be more likely to enforce that covenant. Now, if covenants are in employment contracts, strictly between employees and employers, the court understands that there's an inequality in bargaining power between employers and employees, and therefore they're going to really look at these covenants a lot more carefully. In fact, they're presumed to be unenforceable unless the employer can demonstrate to the court that they are reasonable. And in terms of reasonableness, you're looking at what exactly is being protected here. Is it restrict the employee only to the extent that is necessary to protect the business? How long is the restriction? Anything more than 12 months is you're starting to get. I know there are cases that go as high as 2 years, but I don't feel too comfortable going above 12 months. And then there's the geographic restriction in a non-competition agreement too that is considered, and above all, the provisions have to be absolutely clear or they're not going to be enforced. So bottom line is, include these covenants if you can in the actual sale agreement and not in the employment contracts. Constructive dismissal, and this typically occurs in a share sale. So that's when the buyer acquires a business that has employee, obviously, hopefully, the business has employees and employment relationships, and the buyer tries to unilaterally make changes to the employment terms, conditions of employment. And if the change is not only unilateral, but if it affects a material term or condition of the employee's employment, the court's going to say, look, that's a breach of contract. You're effectively firing the employee, and the employee can, in some cases, in many cases, leave the business and sue for common law damages. I won't say anything more about that other than it's one of those things that when you're buying, especially a share sale, you want to do your due diligence and review the employment contracts and terms and conditions of employment, essentially what the vendor is paying in compensation annually before you buy the business. Other liabilities to consider, of course, ongoing anticipated employment litigation, recent current applications. I think the big one that I would be most concerned about is current or recent applications for certification. That's when you're going to get a sense of that a union has targeted the business and is trying to organize the employees of that business, because unionized work environments can be, and often are, much more expensive. It erodes the net profit of the business. Other things, though, of course, are human rights complaints, civil actions, Ministry of Labor complaints. You want to review for compliance with the Occupational Health and Safety Act. There are mandatory policies in these acts. So you want to ask, for example, a workplace harassment and violence policy. You want to ask for copies of these policies if it's a share sale, so you know they're in place, because getting these policies drafted costs money. So if they're not in place, well, then you can seek a reduction to the purchase price to account for these additional costs that you're going to have to incur. Okay, I'm getting into the last section. How am I doing for time here? Oh, look at that.
You're actually over your anticipated half an hour.
Lawyers talk too much. Okay, I will get through this part relatively quickly, but this is probably one of the most important parts. It's the part about due diligence. What do you want to consider before you sign off on the deal? And first and foremost, the vendor is going to want to estimate the employment liability that will be triggered from a sale, particularly an asset sale. And this involves a review of the termination provisions or the employment contracts that are in place and estimating the potential common law liability. I would say that a purchaser in a share sale will want to do the same thing. They'll want to know what kind of liability are we taking on. Now, in terms of the purchaser, some of that liability is not going to actually occur because many of these employees are going to resign or retire. No compensation is owing in those circumstances, but it's not a bad idea, and it'd be a good argument to make in negotiations that, for example, if you're taking on $4 million in a potential employment liability, well, maybe you want to cut a little off the purchase price. In an asset sale, the purchaser is going to want to know the material terms and conditions of the vendor's relationship with its employees, because if you're going to be making offers of employment to some of these employees, you can expect that these employees are going to want terms that are, equal to the terms they're working on now. So if someone is making an astronomical amount in salary, you want to know that before you buy in. Assets. Again, the purchaser, we're going back to employment contracts. You will want to make your offers of employment based on employment contracts that have enforceable termination provisions. You'll want to, again, identify, some of this is a summary, any employees on a leave of absence and all employees working on accommodations. You'll want to, again, look and make sure that key employees are bound, and this would be more in a share sale, but it would also actually, it would be asset and share, ensuring that key employees are bound by enforceable restrictive covenants. And you want to think about a non-discriminatory basis for reducing the number of employees you're going to take on if you're acquiring the assets of a business. Other things to consider: the cost of benefits that are being provided, the policies. Again, does the employer have all the statutorily required policies in place? And the unionized business, things to consider are, you want to take a look at the collective agreement, and you want to find out when the next round of bargaining is scheduled to occur. And you maybe even want to look at the industry for other collective agreements to see what other employers are paying their employees, so you can anticipate what kind of demands are going to be made at future bargaining sessions. So I hope you have found this helpful. I just noticed that I'm wearing the same suit and shirt today. There's 3 explanations for that. Coincidence, it was planned, or this is my only suit and shirt.
Or we took the photo today.
Or we could have, yeah, there's 4. Keith, do you have any questions?
Let's take a look. Thank you, JP. There's a lot of things to be thinking about when there's just on the employee side when these negotiations are going on, and the more employees, the more things to look at from
the bigger
costs.
the bigger the mistakes, the more employees, the larger the mistakes can be in terms of bottom line costs.
Right. All right. Well, if anybody out there has any questions, please do send them in, and we will stick around for a minute or two and see what we have. Here's one we have. Should a purchaser offer employees fixed-term contracts for a trial period?
Oh, okay. Yep, that's a good question. No. There's a recent law coming out of the Ontario Court of Appeal. There's a case, the one of the names of the parties, the employer, is the Benson Group. And it really shows the potential risk of offering really any employees fixed-term contracts. A fixed-term contract, for those who don't know what it is I'm going to employ you for a fixed period of time. Could be a year, could be 3 years. Typically, employees are hired on an indeterminate basis, meaning I don't know when you're going to be fired. We're going to work together as long as this is working out. So in that case, they offered a fixed-term contract to an employee. I believe it was 5 years. About 23 months into the relationship, the employer says, this is not working out. I'm firing you, and I'm going to rely on the termination provision in our contract. Well, it turns out that the termination provision was unenforceable because it violated the Employment Standards Act, and therefore was void. So the court says, okay, we strike out this termination provision. We're going to act like it effectively is not in the contract. Therefore, employer, you are on the hook for the balance owing on the contract, which was like 3 years pay, which came as a shock for the employer. So what I would say, do not offer fixed term contracts. If it's an asset sale, you may want to include probationary periods in your contracts. If it's a share sale, it's pretty hard to impose a probationary period on an existing employee.
All right. Thanks, JP. Next question. Does a vendor have to issue records of employment to its former employees in an asset sale?
Yes and no. So in an asset sale, of course, the vendor is terminating its relationship with employees. Unless there's any other commitments between the vendor and purchaser, records of employment have to be issued. However, there are some exceptions in the Employment Insurance Act that I believe the requirements are, if the vendor is going to provide the purchaser with the payroll records for the employees, and the purchaser is going to commit to recognizing their service with the vendor when they issue records of employment, when the purchaser ends its relationship with the employee, then you don't have to issue records of employment.
All right.
So put that in your agreements, and that way, if you're acting for the vendor, they don't have to go through the process of issuing records of employment to 100 or more employees.
All right. Thanks, JP. Let's do one more question. In a unionized setting, what happens to the collective bargaining rights if a business in the construction industry sells some of its assets but continues its business in the same industry?
Okay. So unionized context is quite confusing. It's very different, and that is especially the case in the construction industry. So typically in the construction industry, an employer is bound by a provincial collective agreement. So the employer is saying any work that I do, for example, any carpenters that I hire when doing work in the province of Ontario has to be paid in accordance with the provincial collective agreement by, it's usually, for example, the carpenters union and an association of employers that negotiate it. So if the employer is selling, say, its assets in a division, but it's going to continue carrying on business in the province, and it's bound by a collective agreement already, well, the employer is going to continue to be bound by that collective agreement. And you can expect that the union is going to apply for a declaration that the purchaser, the person who has acquired the assets, is going to be bound by the collective agreement as well. Now, asset, if you sell a saw to another company, well, I don't think you have to worry about a union seeking a declaration that its collective agreement binds the buyer of that saw. However, if a portion of the business is moved as a result of a transaction and a number of employees are involved, well, then that's when you get into that scenario where there's going to be an application.
Great. Well, that wraps up our questions, JP. Thank you very much, JP, for the presentation, and thank you to everyone who tuned in today. As mentioned earlier, if you weren't able to download the slides from today's presentation, just drop us an email and we will happily send those along. And we're going to wrap up a little 15 minutes before 1 o'clock, so still time. outside, grab a sandwich and have your lunch errands, and hopefully enjoy the rest of the day. Thanks again for tuning in, and we'll be back in touch with the details for our next webinar before too long.
All right.